On 11 April 1815, the proceedings of the Old Bailey recorded the trial of Eliza Fenning, a domestic servant charged with administering poison to members of the household in which she was employed. The indictment alleged that arsenic had been mixed into a dish of dumplings prepared in the kitchen of her master. The case was reported widely in London newspapers and reprinted in provincial journals. For a season, her name circulated through pamphlet and petition alike. London at that time was a city attentive to criminal trials. The courtroom at the Old Bailey drew spectators from various ranks. Published transcripts, though condensed, were read beyond the walls of the court. Public appetite for such proceedings was sustained by broadsides and the regular columns of the metropolitan press. Eliza Fenning was approximately 22 years of age. Parish records indicate her employment in domestic service prior to the events in question. By the time of her arrest, she was engaged as a cook in the household of Mr. Robert Turner, a law stationer residing in Chancery Lane. Her position placed her in daily charge of the preparation of meals. In late March of that year, members of the Turner household partook of a meal that included yeast dumplings. Soon after, several fell violently ill. Medical testimony later given in court described symptoms consistent with arsenic poisoning. A quantity of white powder was reportedly discovered in a paper packet within the kitchen. The suspicion turned toward the servant responsible for the dish. Fenning was taken into custody and brought before a magistrate. Depositions were recorded. She denied knowledge of the poison. During the committal hearing, witnesses described her conduct in the days preceding the illness. Some accounts portrayed her as dissatisfied with her situation. Others offered no such characterization. The surviving documentation does not supply a uniform portrait. The matter proceeded to trial at the Old Bailey. The prosecution presented chemical evidence and testimony regarding the purchase of arsenic. A shopkeeper asserted that a young woman matching Fenning's description had obtained the substance under pretense of killing vermin. The defense contested the identification and the chain of custody of the powder. Medical practitioners called to the stand described experiments performed to confirm the presence of arsenic in the remaining food. Early 19th century toxicology, while advancing, was not without controversy. Published accounts of the trial reveal that the jury was instructed according to prevailing legal standards, which permitted conviction upon circumstantial evidence if deemed sufficient. After deliberation, the jury returned a verdict of guilty. The sentence pronounced was death. The judgment was entered into the record without delay. Petitions for reprieve were soon circulated, bearing numerous signatures. Pamphlets appeared arguing for reconsideration, citing alleged inconsistencies in the testimony. Despite these efforts, the sentence was not commuted. The case had divided opinion within the city. Some editorials defended the verdict as a necessary affirmation of domestic order and legal authority. Others questioned whether the evidence had excluded reasonable doubt. The debate unfolded in print, in sermons, and in private correspondence. Eliza Fenning was held in Newgate Prison awaiting execution. Prison registers confirm her confinement. Visitors were recorded. On the appointed morning, she was conveyed to the place of execution before a crowd gathered in the customary fashion of the time. On the morning appointed for execution, the yard outside Newgate Prison was filled, according to long-established custom. Contemporary newspapers estimated the crowd in the thousands. Accounts differ in tone, yet most agree that the case of Eliza Fenning had stirred unusual agitation for a servant girl convicted upon circumstantial proof. Printed broadsides describing her trial were sold in the streets. Some emphasized the suffering of the Turner household. Others asserted her innocence and condemned the swiftness of the verdict. Clergymen who attended her in prison law. Her published short tracts recounting her final declarations. These publications circulated widely in London and beyond. Petitions for reprieve had been presented to the Home Office in the days before the sentence was carried out. Surviving summaries of these appeals indicate that signatories questioned the adequacy of the chemical evidence and the reliability of witness identification. The law officers of the Crown reviewed the case papers. No intervention followed. The execution proceeded. Reports describe her comportment as composed. Afterward, her body was conveyed for burial. Parish burial registers confirmed the interment. Within days, pamphleteers began to publish extended critiques of the proceedings, reprinting portions of testimony and offering alternative interpretations of events. The Turner family, whose illness had initiated the prosecution, continued their residence in London. Newspaper references to them became less frequent as public attention shifted to the conduct of the trial itself. The central question, debated in coffee houses and print shops, concerned whether justice had been properly administered. Writers sympathetic to Fenning argued that arsenic was commonly available for domestic purposes and that access to the kitchen had not been exclusively hers. Others maintained that the circumstantial chain was sufficient and that the jury had acted within established legal standards. These opposing views appeared side by side in metropolitan journals. Medical commentary also emerged. The science of toxicology, though advancing, had not yet achieved uniform procedure. Some physicians defended the tests performed during the investigation. Others suggested that methods for detecting arsenic required greater refinement. These professional disagreements were reproduced in periodicals devoted to medicine and law. The case therefore extended beyond the fate of a single servant. It entered ongoing discussions concerning evidentiary standards in capital trials. Parliamentary reform of criminal law was already under consideration in broader terms. Fenning's conviction was cited by certain advocates as an illustration of the dangers inherent in reliance upon circumstantial proof in cases carrying the ultimate penalty. Yet no formal inquiry reopened her case. The official record of conviction remained unchanged in the sessions papers of the Old Bailey. Bound volumes preserved the indictment, the summary of evidence, and the sentence. For the legal system, the matter was concluded. Public memory, however, proved less settled. In subsequent months, poems and moral reflections referencing her fate appeared in minor publications. Some portrayed her as an example of youthful misjudgment, others as a victim of hasty justice. The diversity of portrayal reflects the divided reception that marked the trial from its beginning. The execution had been carried out according to law. Whether it had satisfied the demands of justice remained a matter contested in print. In that tension between verdict and public doubt, the name of Eliza Fenning endured beyond the scaffold. In the years following her execution, the name of Eliza Fenning continued to appear in print, though less frequently than in the months immediately after her death. Pamphlets first issued in haste were gathered into bound collections. Marginal notes in surviving copies show that readers returned to the testimony, comparing statements and weighing the consistency of the evidence. The official record, however, remained unaltered. The printed sessions papers of the Old Bailey preserved the indictment and the jury's verdict without commentary. No notation of doubt accompanied the entry. In the structure of English criminal law at that time, execution concluded the matter. Writers concerned with criminal jurisprudence cited her case in broader arguments for reform. During the early decades of the 19th century, Parliament gradually reduced the number of offenses punishable by death. Debates recorded in Hansard reflect an increasing unease with the severity of the so-called Bloody Code. Though Fenning's name was not central in every discussion, her trial was occasionally invoked as an instance in which circumstantial evidence had led to irreversible punishment. Medical commentary also evolved. Advances in toxicology during the subsequent decades introduced more reliable methods for detecting arsenic. Later authors, writing with knowledge unavailable in 1815, reassessed the procedures described at her trial. These retrospective evaluations belong to historical analysis rather than to the contemporary record. The documents from the time reveal only that the jury accepted the testimony presented to them. The Turner household gradually receded from public notice. Trade directories list Robert Turner's continued professional activity for a time after the trial. No subsequent proceedings altered the outcome of the poisoning charge. The illness that had given rise to suspicion was remembered chiefly because of the capital sentence that followed. Within popular literature of the mid-19th century, Fenning's story appeared in compilations of notable trials. Editors abridged testimony and added commentary suited to their audiences. Some volumes treated the case as a cautionary tale concerning domestic service. Others emphasized the possibility of wrongful conviction. In each retelling, the basic facts derived from the same court record and newspaper reports. As decades passed, attention shifted toward other celebrated trials. Urban growth altered the neighborhoods once associated with the case. The physical environment of Chancery Lane changed. New buildings replaced older residences. The scaffold outside Newgate, once a recurring site of public spectacle, ceased to function in the same manner as penal practice evolved. Newgate Prison itself was eventually demolished in the early 20th century. Its disappearance removed a prominent architectural reminder of the execution. What remained were printed pages, court transcripts, pamphlets, sermons, and the occasional reference in legal commentary. Today, her name is seldom spoken outside academic study of 19th century criminal law. Yet, in 1815, it was printed in bold type across London broadsheets. Crowds gathered. Petitions circulated. Members of Parliament received appeals. The scale of attention demonstrates that her trial was not obscure in its own day. The archival record neither proclaims innocence nor confirms guilt beyond the verdict delivered. It preserves testimony, counter-testimony, and the formal language of judgment. Within those pages, Eliza Fenning appears as she did before the court, a young domestic servant accused, tried, and sentenced according to the legal standards of her time. In that preserved record lies the measure of her former notoriety. The city once debated her fate with urgency. Now it rests in bound volumes consulted by a narrower circle. The documents endure, and with them the memory of a trial that once divided London.